Hello, my name is Madelin Einbinder, and I'm a judge from New Jersey who handles children in court cases, which are those matters brought by our child welfare agency known as the Division of Child Protection and Permanency. In my jurisdiction, we have a unified court system in which all of the judges serve in different vicinages for a central governing structure. My jurisdiction began engaging youth in our hearings in 2015. So what was the spark for New Jersey to begin engaging youth in their hearings? The simple answer is that there are statutory and court rule requirements for youth participation. The real answer is that there is a benefit to having children participate in the process. They can assist the judge in making decisions and ordering services for the youth and their families. Our objectives were that youth should be present and heard, and that if the court and the stakeholders were working for the best interests of these children, wouldn't they want to see the decision makers and hear those conversations and decisions? Both federal and New Jersey law favor youth participation in court. Clearly, everything we do in this arena is about the best interests of the children. But what does that mean? It should mean these youngsters have a voice in what will happen to them. It became apparent to us that kids need to be in court. One of the first times a youth appeared before me, I felt that I could connect personally with that young person. I meet with the kids in chambers without my robe and have an informal conversation with them. They see that I'm a normal person, not just a scary figure in a black robe. Moments like these help ease the fears of youth and show them I care about them and that they can speak with me on a personal level. Our partners, such as CASA, court-appointed special advocates, have also helped, making gift cards available to them. Nothing gets a teenager smiling more than a gift card to a beauty store like Ulta or a gaming store like the GameStop or even Target or Walmart. These $10 cards are like gold to them. Many times they can feel better about speaking their minds, even if it's hard for their parents to hear. There have been several instances in our courtrooms where a child's words changed the course of hearings. For instance, a 15-year-old testified in front of a judge during a termination of parental rights trial that he wanted a plan of independent living, not termination. He had a previous history of delinquent behavior, including an adjudication for sexual assault. It seemed unlikely he would be adopted, and a plan of independent living seemed to make sense. His sincere testimony that he wanted to maintain a connection to his mother led the judge to schedule a new permanency plan in the middle of the trial. The division was ordered to assess him for that program over their objection. He was found to be a good candidate for independent living, and the judge changed the plan. By the time the matter returned for a new permanency hearing, the child had turned 16, and the independent living goal was adopted. Another judge, during a permanency hearing, heard from a biological mother how bad the division was, even suggesting they kept the child in a group home just to make money. She wanted the child to be placed with an adult sister who had been approved for independent living. The child spoke to the judge after that, saying both he and his adult sister were broken due to their mother's actions, and if he had to live with his sister, it would be a constant reminder of what they had both endured. The judge adopted an alternate plan. A 16-year-old told the judge she did not want to go back to live with her father because she had to change schools every few months, twice returning to the district where a family friend lived when her father was homeless. She told the judge how painful it was for her to have to explain to teachers and others why she was back again each time. She couldn't join any athletic teams or participate in academic undertakings or other extracurricular activities due to this transient lifestyle. Her wish, although she loved her father and knew he loved her, was to stay with the unrelated resource family who had shown her what a stable life could offer her. The judge rejected the plan of reunification with her father, and the child remained with the resource caregivers with a goal of independent living. As with any changes, there are challenges. Youth may not want to come to court. There was an initial concern that child participation wouldn't have an impact on the decisions. Some of the professionals argued that the children would be traumatized. We learned through this work that the youth have already experienced trauma. Participating in the court hearing allows them to feel empowered, giving them a say in what happens to them. Of course, as judges, we must help the youth understand the difference between their desires and our final decisions. We are guided by the child's best interests as well as their safety. These are some of the hardest conversations we as judges will ever have, but we must be honest. These young people know what's going on with their parents, and to do anything else would not be fair to them in the end. There were also local concerns about not having enough time to conduct hearings with youth and further burdening caseloads that were already overwhelming. We have local advisory committees chaired by judges. These committees include attorneys, all stakeholders, and child welfare professionals. These committees worked together to adjust calendars, address transportation issues, waiting rooms, and waiting times, as well as to allow more time for the youth hearings. So how did we get here? In 2013, there were over 7,000 children in placement in New Jersey. For the most part, we were making decisions without their direct input. As judges, we can convene the stakeholders who do this work. Our positions allow us to gather the important players and champion consensus for the sake of the children and families. In my county, we started with the obvious, making sure the youth knew about the hearing so that they knew that we were doing everything we could possibly do to make sure they were comfortable and familiar with the procedures. We wanted to encourage the youth to attend what could transform their lives. Much was being done to succeed in getting youth to court and engaging them in the process. The law guardians who represent the children in these cases developed age-appropriate noticing materials to give the kids as much information as possible about the hearings. We wanted to let them know who was in the courtroom and their roles in the process. But we knew notice alone was not enough. We wanted the youth to be active, to participate fully in the decisions we were going to make. We worked closely with law guardians and the adolescent caseworkers who built relationships with the youth to encourage participation and to work out the logistics of having the youth in court. We knew we were on to something, that all of this could really work, could really make a difference in the lives of children and youth. So we decided to try and institutionalize it. In 2015, we adopted a protocol to require notices to children, letting them know that they had a right to participate in their permanency hearings. Those are the age-appropriate notices that the law guardians developed. The judges could have the youth participate in chambers so they would feel more comfortable speaking. To ensure due process and transparency, I advised the youth that the parents could hear the recordings. We piloted the protocol and we surveyed youth before and after hearings. The results were staggering. 97% of the youth who attended court said they were glad they were there. 99% reported they would come again. And 90% of the youth said they were able to talk about issues that were important to them. There was consensus that the youth had a better understanding of the case plans, and we found prepared youth were satisfied with their court experience. With this data to support our assumptions, we were able to issue the protocol as an administrative directive, which has the force and effect of a statewide standard in New Jersey. So what else can we do? During the COVID-19 pandemic, we assumed it would be easier for youth to participate in the hearings because they were virtual and transportation would not be required. However, we found in some instances, there was a digital divide that prevented youth from participating due to lack of access to technology. We also learned that law guardians didn't have as much access to their clients in a public health emergency. So unfortunately, it seems that COVID has contributed to a reduction in youth participation in our hearings, rather than an increase. In moving forward and ensuring that the youth have a voice in their lives, we are focusing our efforts on tracking and evaluating youth participation in the permanency hearings. We want to make sure that data inform and guide us in our work. If youth are not attending or participating in our hearings, we want to know why and how we can improve in that area. We also know that older youth who might be aging out of our system have different needs than younger children. Although permanency hearings serve the purpose of approving a case plan, older youth need more than that to help them focus on transitioning to independence. So we're in the process of developing something called benchmark hearings. These are youth-driven hearings where the youth can invite an adult support person to be present, and most importantly, make the decision as to whether their parents can participate. In this hearing, the youth's voice is the priority. We want to help them identify their interests and skills to formulate a life plan that is practical and attainable. For example, they may love music and aspire to be an entertainer, but not everyone can be famous. If they possess good technical skills, for instance, they could be a sound engineer. At the benchmark hearing, the judge and the supportive adult can provide that reality check for the youth to create plans with attainable goals while still encouraging the youth to achieve their dreams. As judges, we have a parens patriae responsibility to the children who are the subject of the matters before us. How can we justify making decisions about children that substantially impact their future without hearing from them? The numbers support this position. We owe these young people the chance to weigh in on what should happen to them. I end with this quote from Nelson Mandela. What counts in life is not the mere fact that we have lived. It is what difference we have made in the lives of others that will determine the significance of the life we lead. Thank you.